Good afternoon. I hope you enjoyed your lunch. We were grateful for a good lunch, and I know that Charles Haynes helped arrange that with his staff. Thank you, Charles. We have three people with us this afternoon as resources for talking about Sharia. As you know, if you've been here all day, this is a topic that has come up at least once in all of the discussions and at some length in the previous two panels. I think that my expectations for this particular conversation are what I would call minimal but basic. I think it would be a superlative goal if at the end of this conversation we had some definitive idea of what Sharia means, how it is distinctive, how it relates to American law, and perhaps what it's not. I can't ever remember being a part of a symposium, especially an interreligious symposium or a public symposium, that was convened to study the Ten Commandments or to study the Sermon on the Mount or to study canon law in the Episcopal Church. I hope there's nobody here that would have gone to a session like that. I would think it'd been pretty dry. But we have this panel and this time for discussing Sharia, which is somewhat unique in itself. Our panel members, you have their extensive data in front of you. Julie Macfarlane, professor of law at Windsor, fellow with ISPU. Julie, welcome. Sadakat Kadri, author and barrister, Doughty Street Chambers. Marc Stern, Associate General Counsel, American Jewish Committee. Now, it should be readily apparent that you have here a Baptist minister with three lawyers. So I'm going to
We're
watch.
outnumbered.
I know I am. And I'm going to watch very carefully any generalizations that I make. It is a unique time. It is an important issue, and I want us to get right to it and involve you in it as much as you want to be involved. In the United States, Sharia is a kind of boogeyman. It gets criticized more than understood. So I really want to begin just with this fundamental question of what is Sharia, knowing that the three of you may or may not agree even on an answer to that question, to what is it analogous, or is it analogous to anything? I mentioned the Ten Commandments, the Beatitudes. Is it like that in any way? What's the meaning of the word itself? And what does that tell us about the law? What does it include? What does it not include? How does it vary from culture to culture? Would we get the same answers as to the question of what is Sharia in one part of the world as we would get in another part of the world? How does the observance of Sharia change from culture to culture, from region to region, if indeed it does? So let's begin there, and I want us really to get to all of those questions at some point. And if we don't get past the first question, that's okay. I have only one other one I want to ask anyway, for sure. So let's try. And Julie, why don't you start us off? What is Sharia?
Good afternoon.
First of all, this is, of course, as many people acknowledged by a slight rolling of the eyes around the room, an extremely large question. And I want just, first of all, to say something about the bogeyman aspect of this. I concluded a study about 2 years ago that I did with Muslim Americans and Muslim Canadians on their practices of marriage and divorce. I talked to all of them about what Sharia meant to them, as well as to many of their imams. But when I told my colleagues, my professional colleagues, and I would say especially my colleagues in the feminist community, that I was doing this work, I consistently got the reaction that has just been described by Welton as the boogeyman reaction. Oh, so you mean they have divorce in Islam? Don't they just stone the women? Gales of laughter. So I became very conscious very early on that there were enormous stereotypes out there that it was really important to try to dispel. So let me try to concisely answer Welton's question, and I'm sure my colleagues are going to add to this, from the basis of my research, because that's the information I have. I'm a non-Muslim, and I'm basing much of what I'm going to say today from what I learned by doing that study. One of the very first imams that I interviewed told me there is a Sharia for every Muslim, which made me go home and think very hard about that. And of course I realized as I read more and became more familiar with the distinction between the Sharia, the path, the principles of good Muslim living, and the Islamic law, which is a subset of the Sharia but not identical with it. And in fact, this expression Sharia law that we hear all the time is a misnomer for that reason. I became aware of the fact that, yes, indeed, every Muslim in every part of the world will understand what those principles for good Muslim living really mean for them. As I went deeper into my study, I found that what it resembled in a symbolic way for the vast majority of the men and women that I was interviewing were the ways in which they approach marriage and divorce. In other words, the milestones of their lives and some of the ways in which they would both celebrate and also, if you like, get closure on those particular milestones. But that, again, their understanding of what those quote-unquote rules actually were varied enormously. I found a huge range of practice across the United States and Canada when it came to, in particular, the sanctioning of divorce for women. A huge range, and I can talk more about that later. But I want to just address a couple of other things that were very clear to me from my data that I think raise some of our preconceptions about what Sharia law actually means. The first I've already mentioned, that it's some sort of rigid, uniform body of law. Another is that it is somehow inherently different in its values and its underlying principles to any other body of law or any other religious beliefs that others might have, that it's somehow far more negative and hostile and violent and so forth. And I think that is a core part of what fuels some of the bogeyman aspect of this. In fact, having done many different studies now of divorce, it will not surprise you to learn that the divorcing couples that I met doing this work were really no different in terms of what was important to them and the values they had about staying married or becoming divorced than any other couples with any other faith or of no faith. The other thing that I think people believe about Sharia is that it causes Muslims to reject the U.S. legal system or the Canadian legal system. And again, my data was extremely clear and consistent on this. Muslim Americans use the courts just like other Americans do, where they cannot make an agreement for a divorce outcome that would be based on what they would understand to be Islamic principles. They'll go to the court and get a divorce. Everybody in my study who was married and used a legal license to do so, 95% of the people I interviewed, also got a civil divorce in the courts. They would perhaps have some procedure with the imam where they felt that they were released from their nikah, but they would all go and get a civil divorce. This is not a substitute. It is an addition to the existing system, and I think the same applies to many other faith communities. And the last, I think, misconception that I just want to address before passing this on that, again, my research showed clearly is ungrounded, is that as well as having different values, which I don't believe is made out, as well as being somehow a rejection of the U.S. legal system, which I don't believe is made out, it is also something that Muslims want to impose on non-Muslims. And this is behind these banners we see on highways, Sharia law is coming, and I'm sure we'll get into this later, many of the efforts to change the state constitutions around Sharia. I didn't meet a single Muslim, and I interviewed hundreds of people who thought that there was any possible sense in requiring a non-Muslim to be somehow compelled to follow Islamic principles. In fact, it's an inherent principle of Islam that there should be no coercion in religion. So again, it seems that there are many straw men out there, which I think we can very clearly take down. Thank you.
Sadakat?
Hi, yeah. Well, I came at this from a slightly different perspective from Julie. I am a Muslim. I'm also a lawyer, but I've recently written a book all about Sharia, about the history of Sharia, and about how it's practiced in countries around the Muslim world. I spent about 6 months travelling around, starting my father's birthplace and going through Pakistan, Iran, and all sorts of other places. The reason I became interested in it in the first place was because the book that I wrote before this one was about Western jurisprudence. And I was living in New York in September 2001, in downtown Manhattan, in fact, on September the 11th, 2001. And so I was around when the whole thing kicked off that we all know about. And everyone then was talking about Islam. Everyone was talking about what Islam required of its followers, what it didn't require of its followers. There were people who said, well, Islam is a religion of peace. The very word salam means peace. And there were other people who said, no, nonsense. Islam is obviously a religion of war, because look at what these people have done. While I was writing my first book, I listened to all of this, of course, but it wasn't relevant to what I was writing. My book was about Western jurisprudence. But the book came out in April of 2005, by which time I was back in London. 3 months later, we had 7/7, the bombings of the London transport system. And the whole cycle started all over again. We had people saying Islam, this has got nothing to do with real Islam. It's got nothing to do with Islamic law. These people are betraying Islam. But then there were other people who said, well, hang on, wait a minute. These guys committed suicide in the name of Islam. They say that they were acting in the name of God. Why don't we take them at their word? And that's what, and I wanted to find out, because I'd written a book about legal history, because I was a lawyer, but also because I was a Muslim, I wanted to find out what the answer was. And so I started with my dad, who's also a lawyer, who's also a Muslim. I said to him, what does the Sharia actually say about this? And he, of course, said that suicide is forbidden by the Quran and by reports about the Prophet, by what Muslims call hadiths. But I said to him, well, where's this written down? Where are the rules written down? But apart from, beyond saying that there were collections of hadiths and there was the Quran, he couldn't actually point me in the direction of any particular sources. And the more I asked, the more I realized that there was this uncertainty among Muslims themselves about what the Sharia involved. And that's something which just struck me again and again and again. Everywhere that I went, there were plenty of people who had ideas about what was good and what was bad, but the idea, the Sharia is a mystical concept, and it's not at all easily defined. So one good place to start defining is with the etymology, with the definition. And the word itself means a path to water, which was obviously in the 7th century a very important path to a desert people. But it's got a metaphorical meaning, an obvious metaphorical meaning, which is that it's the route towards salvation. It's got an almost precise Jewish equivalent, the halacha, which means the path to be walked. In my book I say that the closest English Christian equivalent would be the straight and narrow, the path that you follow to get where you want to go, to attain salvation. But that's as far as one can really define the Sharia. What people tend to be arguing about when they talk about the Sharia is another word, fiqh, which means in Arabic understanding. And arguments about the fiqh have been going on for 1400 years. They're still going on today. Arguments about whether, for example, the punishment that's appropriate for an adulterer. In the 7th century in the Quran, it said that the punishment appropriate for an adulterer is 100 lashes. Incidentally, the punishment appropriate for someone who falsely accuses someone of adultery is 80 lashes, so there's a counterbalance there, but that's by the by. After the Quran was written down, there were other punishments. So it was said by other people, and it was supported by hadiths, which were written down 150 years after the Quran, that actually stoning is the right punishment for adultery. Now, I don't want to get too detailed here, but that's one example of the kind of issues that arise when you're talking about fiqh as opposed to Sharia. The Sharia for a devout Muslim just means the right path to follow. So that's, I think, one of the most important aspects of the problem that America is facing at the moment in addressing this issue, that people are conflating these two concepts. People are attacking the Sharia, which, as far as a Muslim is concerned, a devout Muslim, any Muslim really who applies their mind to the matter, as far as they're concerned, an attack on the Sharia is basically saying, don't do the right thing by God. You don't just ignore God, which is obviously nonsensical. If what you really are trying to do is attack violent extremism, is attack extremist interpretations of Islamic law, because those extremist interpretations deserve to be attacked, and I certainly am on the side of those attacking them. I do attack them in my book, but that's what should be targeted. That's what should be focused on. And the kind of absurd measures that we've got in 24 states at the moment, just recently passed into law in Kansas, and you've got a sheriff standing for office down in Texas on an anti-Sharia ticket. It just makes no sense at all. If you do want to counter something which you think is a real threat, if you really think there's a possibility that American courts are going to one day incorporate stoning to death or the subjugation of infidels, then target those particular interpretations. Don't target the Sharia itself. And that's sorry, that's probably slightly long for an introduction, but I think that's there is this crucial distinction between the Sharia and between fiqh, and it's the interpretations of Islamic law rather than the Sharia around which these debates should really be centered.
Mark?
Well, I'm not going to pass myself off as an expert on Sharia or fiqh. I'm not. The parallels to Jewish law have already been drawn. I'll close with that in a different way. As an American constitutional lawyer whose specialty is religious liberty, I must say it does not matter very much if one is talking about Sharia or fiqh or Islamic law or any other categorization. The question from in a legal sense, and then in a larger way in a sociological sense, is the way that minority religious groups, and in our American legal history, traditionally immigrant, at least originally, religious groups ought to be able to set up a sort of state within a state. That is the legal question. One goes back and looks at, for instance, the reception of American Catholics. One will find much of the same reaction about canon law and some of the myths about what was going on in Catholicism. Jews encountered this, and now Muslims are encountering it. I must say, in some ways, in milder form than, for instance, Catholics did. We've not had real anti-Muslim riots or the wholesale slaughter of people in convents and so on, which we had in Philadelphia and in Maine and Boston in the 19th century. So as bad as things are, they've been worse. But American constitutional law is, first of all, in one sense, Protestant in its approach to what religious beliefs are. That is to say, it's very much based on the individual's perception of his or her religious duties as opposed to the court's interpretation of what's the correct interpretation. The lead case, actually a colleague of mine had the key sentence plagiarized from her brief without accrediting by the Supreme Court. Thomas was working as a welder in some steel plant. Plant got a contract to build tanks. Thomas said, well, I'm a Seventh-day Adventist, or a Jehovah's Witness, I've forgotten. And he said, my religion won't let me do this. So when he's fired, he seeks unemployment benefits. And the company, trying to defend not paying him, says, well, we've got experts from the religion. We've got clergymen who'll swear up and down that there's nothing wrong with, let's say, a Jehovah's Witness or an Adventist working on tanks. And the Supreme Court said, the courts are not arbiters of biblical interpretation. If Thomas sincerely believes that this is what his faith requires, that's good enough for us. So, and I think that's clear. I mean, it's the Supreme Court, so it's binding law on everybody. Occasionally, a judge, particularly a lower court judge, will stray, but they almost always get quickly set right. And so it almost doesn't matter for these purposes exactly which term you use and how you categorize it, or even if you argue that certain interpretations are wrong. I'm always amused when I see it comes up most frequently in the United States, but it has in France as well. People argue about whether women covering their hair is required by Islam or not, and therefore whether they have a religious liberty claim. And I sort of laugh and say, no, the Supreme Court has said it doesn't matter. And so I'm not interested. I skip those pages in the brief. Whenever I come across such a case, I skip those pages because they're legally irrelevant. That brings me to what I think is the much harder question. However one defines or labels the particular religious law we're talking about, what is the right of groups and individuals to order their own lives as they see fit? If there's no controversy and both sides are happy, then nothing comes of it by and large. Although in Canada and Ontario, actually, they've even banned consensual arbitration according to religion, but that has not been done here, and with the exception of the Oklahoma, now invalidated Oklahoma constitutional provision, none of the subsequent bills really do so either. At least if you have a lawyer who knows how to read, it's very easy to get around those statutes. Not everybody has a lawyer who can read, but that's a different question. So when do things become difficult? Well, things become difficult in two ways. One is when one party tries to coerce another party in ways that most of us would think of as coercive, although it may be perfectly legitimate within a particular religious tradition. And there's an imbalance of power or knowledge. This was the great fear in Ontario when they eliminated arbitration for domestic relations and child custody matters. The theory was that immigrant women did not realize they had access to an alternative system, and that anti-women, particularly anti-egalitarian treatment of women in divorce would prevail in the religious courts. That remains a subject of much discussion, and there at least there's legitimate grounds for discussion whether we ought to permit those sorts of arrangements. So that's the very hardest issue on an individual basis. On a communal basis, the question is whether society can tolerate those sorts of imperio in imperio, a nation within a nation. The United States has been remarkably tolerant about this over time. So Catholics have had marriage tribunals since who knows when. And the Jewish courts have issued Jewish divorces and settled custody, not child custody, because that's generally reserved to the civil courts almost everywhere, but property settlements have, and if there's no controversy, those go on. As long as there's recourse to the civil courts for a civil divorce, which is almost always done in any event, there's no controversy about it. But the sociological problem remains. Is it wise to allow people to operate in their own subculture? Can we tolerate it? The European answer seems to be no. You remember the Archbishop of Canterbury almost lost his proverbial head when he suggested to the contrary. Americans mostly shrugged, couldn't figure out what the controversy was about, except that it was Islam and that was controversial. But in America, that we don't worry about that very much. But some of what motivates the anti-Sharia people is that. And that at least, there are issues there which at least need discussion, particularly since I think it certainly this is true in my own community, but I can't imagine it's not true in Islam as well. In fact, there are cases that have arisen which indicate that it is true, that where you have aberrational decisions that depart very much from the notion of equality, which is so central to Western thought, that remains a hard problem. And finally, with this, I'll close. I want to caution about allowing the discussion, at least as it impacts on the anti-Sharia laws and the role of Sharia in the courts, which is anyway barred. The courts can, as a constitutional matter, impose it on unwilling parties. But in a larger theological sense, I think it's a mistake for the opposition to those laws to be based largely on a liberal reading of the Islamic tradition. This happens, and I speak out of the Jewish tradition, where so-called liberal, which is a small L, Jews and more traditional Orthodox Jews fight about the nature of Jewish law. And that then becomes the debate. Is Jewish law this soft, cuddly, humanistic body of practices, changeable fairly easily, or is it something else? And as far as I'm concerned, that's legally irrelevant, except in the extreme sociological cases I talked about earlier. And I think it would be a mistake to make a defense of Islam's right to function in the United States dependent on a particular reading on a similar spectrum of understanding the Islamic tradition. Because absent some important state reason, even the extremists should not be interfered with in their teachings by the state.
Let me follow up with each of you, and then I want you all to have the opportunity to interact with each other. But Julie, just clarification on yours. Your references mainly were to what I would call domestic issues, marriage, divorce. Do you see Sharia with applications larger than just those issues?
The men and women that I spoke to, and I think this is borne out in many other studies actually, when they talked about the realization of what Sharia meant to them in their daily lives, spoke either about observances or they spoke about life's milestones, marriage, divorce, burial in some cases, and so forth. But I want to just kind of connect this a little bit. I think there's a very complex relationship between what these values and principles mean to ordinary people and the way they get played out in the courts that I think there is a lot of misunderstanding about. One of the points which Marc referred to as well is that we're not talking about these rules around marriage and divorce or principles as being a substitute, but rather being a complement to using legal licenses to marry or legal decrees of divorce. And again, I entirely agree with Marc that it would be a mistake to base our defense of Sharia on a very liberal reading. But I think it's much more important to base it on the reality of what is actually happening in our courts. The anti-Sharia movement produced a report about a year ago now. This is through the Center for Policy Security, or Security Policy, I beg your pardon, in which they listed the top 20 scary cases that Americans should be worried about when it came to seeing Sharia overtaking our society and our civilization. And I can only imagine that they got away with that because nobody, other than perhaps myself, could be bothered to go and read the cases, most of which I'd already read. There were one or two I hadn't. On their analysis of the top 20 scariest cases, and this comes back to your first question, Welton, of those cases, 9 of the 20 were comity decisions. In other words, they were American courts looking at whether or not to uphold an order in the family law area made by a court in a Muslim country. And of course, this happens whenever anybody has an order for child custody or support or divorce in a country outside the United States. They want it to be enforced here. They have to ask the court if they will recognize it. So 9 of the 20 were comity decisions. Another 8 involved the nikah, which is the marriage contract that many Muslims will sign as a celebration of their marriage, and whether or not that could be legally recognized. In the majority of these 20 cases, in fact, the court decided it would either not uphold the Islamic law's decision because there were concerns that they had adopted principles different to American principles. In other words, the standard, which is supposed to be procedural only, is in fact far stricter when it comes to countries looking for comity which are Muslim than countries which are non-Muslim. So it kind of makes the reverse argument. And in the case of the nikah, the vast majority of times that a court has been asked to recognize the nikah, usually because a woman is trying to get what she has been promised in her nikah on the event of divorce, which is a lump sum payment of some form, in the vast majority of those cases, the courts won't recognize those contracts either, because they say they are contracts for a religious purpose, which of course the courts are not allowed to enforce. So if you actually read what those who argue for the need for this kind of measure put out as their jurisprudential basis for why we need it, it is entirely without any substance. And I think that, you know, we need to be focused on the fact that what this is really about are family traditions and cultural norms and customs, which for some people are relatively secular, for others are more religious in a formal sense, but they amount to getting married, getting divorced, or sometimes trying to enforce something that might have happened before that event to that family in another country.
Okay, but now I think I understood you to say that Islamic law is a subset under Sharia.
Right.
So how do you define Islamic law?
Well, I think that the term is fiqh, is the intelligent way to put it. So if you look at all the things that you might be required to do as an observant person in any faith, some of them are obviously more susceptible to enforcement than others. You know, enforcing people's faith in God would be a little bit difficult to do. On the other hand, saying that we believe that to be committed as a Muslim to marriage, you have to sign a marriage contract, that's a little easier. So if you look at Muslim law around the world, you'll see that the vast majority of what survives colonialism, because there used to be a commercial and property system that was Islamic, but that has basically disappeared now, what survives colonialism is family law. So if you go to any Muslim country today and look for what the courts are doing that has as its base Islamic law and Islamic principles, it's marriage and divorce, it's family inheritance, it's issues that relate to domestic relations.
Sadakat, you used a word that I didn't expect to hear in this conversation, the word mystical. And I'd like for you to elaborate a little on that, and then where I'd like to go with it is, Marc was saying, doesn't really matter what you call it, the principles here are bigger than those words or the categorization. Talk about Sharia as the mystical path and how that relates at all to secular law.
Sure. Well, when I started writing the book, I went back to my father's hometown because it's known as a place where you go if you're possessed by a genie. You will go there to be exorcised. And you aren't just exorcised, the jinns are commanded to leave according to the Sharia, because it's expected that they will also, the jinns means genies in case you don't know, they're also regarded in Islamic tradition as being subject to the Sharia as well. And I just thought that was a good way of kicking in, because even though I am a lawyer, I didn't write this book as a lawyer, because I realised pretty early on that the Sharia was going to be something far broader than simply a list of commands and a list of punishments, you know, the way that we Western educated lawyers tend to think about laws. And so that's how I started the book. But the Sharia extends to rules, as we all know, about about diet, about dress, about good manners, about when fasting should start, when fasting should end. There's almost literally nothing that that a Muslim will regard as falling outside the Sharia, because the Sharia is the path through creation that God has ordained for a faithful person. And if you follow that path, you're going to get there at the end. But there isn't anything that God has that's beyond the purview of the Sharia. The practical question is, of course, enforcement, and is what practical impact that's going to have. Mm-hmm. And of course I completely agree with Mark that these distinctions between Sharia and fiqh are at one level unimportant, because actually it's what communities want to do which is the most important thing. As a matter of US constitutional law, as a matter of human rights law anywhere in the world, that's obviously true. But the two things I'd say about that. First of all, the distinction that I drew between Sharia and interpretations of Islamic law, human interpretations of Islamic law, is important because the attack is being mounted against the Sharia, and that's people aren't drawing any kind of distinction, and because that attack is being made, it actually alienates many of the people who shouldn't be alienated, who should be arguing on the same side. If someone hears that you're against, I completely understand the fears of violent extremism. You know, I was here on 9/11. I was in London. I was a commuter on the day that the trains were bombed in London. I understand. I don't want to be standing next to a Muslim guy with a rucksack that's going to blow up. But the crucial thing is that the number of Muslims who do that are a minuscule minority, and you're going to alienate a lot of people if you focus on the Sharia, and therefore it's important to recognise the hugely expansive dimensions that the Sharia has, not because that's relevant to constitutional law, but because that's relevant as a matter of practical politics. And in terms of what Islamic law does require to be enforced and what it doesn't require to be enforced, there isn't a simple answer. You know, I went to countries like Pakistan where there are horribly misogynistic interpretations of Islamic law, which scholars say need to be enforced. Stoning to death is on the statute books. It's never been enforced in all the time that it's been there, but it's there. Amputation is on the statute books. Again, never been enforced, but it's there. It occupies this strangely symbolic value in many Muslim countries. There are some countries where it's enforced, but actually the weird thing is that in many Muslim countries, there's about half a dozen countries which claim to enforce these penalties, but it's only really in Saudi Arabia and in Iran where they're still enforced as a matter of practice. You know, apostasy, blasphemy. These crimes are said to be punishable by death in places like Iran or in places like Afghanistan even, but they're not actually enforced. And there's a huge battle that's being fought at the moment between a small minority of people who say that these things should be enforced, and between the large majority of people who don't want them to be enforced. You know, even in places like, probably especially in places like Egypt, the Muslim Brotherhood may have been voted in, but the Muslim Brotherhood has never claimed that it's going to be imposing these penalties. They exist at some level, at some nebulous level as part of the Sharia, but they aren't actually part of of the Muslim Brotherhood's political program. And the same is true in many other countries in the Muslim world. And there isn't a simple answer about what is and what isn't enforceable under the Sharia. There are arguments to be had about that. And you know, sometimes when I've spoken about the Sharia, people will say to me, "Well, tell me some good things about the Sharia, and tell me some bad." You know, I mean, there are plenty. It's like a flip side question that I had in Iran. People saying to me, "Well, tell me some good things about American justice." Mm-hmm. You know, I mean, there are good things about it. I studied here. I know there are, but you know, it's too vast a question to be easily answered.
I think people who use Sharia as a fear tactic do what people wanting fear do and turn to the extremes. So if they're looking at Saudi Arabia or they're looking at Iran, they're calling that Sharia. You call it a mystical path. Is what they're doing Sharia?
I'm not going to say that some of the people who impose those penalties and who believe in those penalties aren't motivated by their version of the Sharia. Of course they are. I'm not going to question.
They just take it to an extreme.
They have their own view of it. You know, they will say that amputation is the appropriate penalty for theft. They will say that stoning is the appropriate penalty for adultery. Just as there have been it certainly has been imposed at times in Islamic history, much more rarely, interestingly, than is commonly acknowledged. And one of the most interesting statistics that I came across was in the 500-year history of the Ottoman Empire, the empire that ruled lots of the Muslim world from Istanbul. The total number of stonings to death for adultery recorded in court records is 1 in those 500 years. But these penalties have been enforced. There are people who say that these are part of the Sharia, and I'm not going to question their good faith. That's not for me to do. But that isn't typical of the Muslim world, and it certainly isn't necessarily part of the Sharia. And if I can just very briefly, can I just talk about the
One quick question. Just one thing. I once spent a day trying to figure out the proportion of the Muslim worldwide population that lived in the countries that actually used these penalties, relative to the Muslim population worldwide. And I'm not trying to say that this is scientifically absolutely on the button, but I spent a day on this, and it was 7%. In other words, our news media tells us constantly about these barbaric penalties in what they describe as Sharia, as if this is the mainstream of Sharia, and in fact the population of those countries in the world in which these penalties are actually being carried out is approximately 7% of the Muslim population worldwide. Just as a reality check. Sorry.
I'll only say this: are we going to be talking about the arbitration courts in the European system, or is that something that I should mention now? Because
go ahead and mention it.
Okay, because again, picking up on the point that Julie spoke about earlier on, Mark actually I think had it righter when he said that in Europe. That there's more concern about this. It's not actually the case that in England the government has given a green light to these tribunals in the slightest. It's actually the opposite. There are tribunals which operate. When the Archbishop made his comments in February 2008, they caused a furore. And the Lord Chief Justice did step in afterwards, and he said, look, actually all that's happening here is, as Mark said, communities are within the bounds of what our equivalent of the Bill of Rights, the Human Rights Act and the Children's Act and judicial review and all these other safeguards. Within those bounds, communities are able to govern themselves in a certain limited number of areas, not criminal jurisdiction, not family jurisdiction involving children, etc., etc. And yet there still has been this huge outcry. But if you actually look at what these tribunals do, Julie's written all about this in her book, in the American context, but also in the English context. They don't. First of all, they've got to be consensual. It's impossible to go to these courts unless they're I call them courts. I'm falling into the trap myself. They're tribunals. They're bodies. They're mediation bodies. But the 95% of the decisions deal with women who go to them because they cannot get an annulment from their husband. Their abusive husband, has walked out of the marriage and he hasn't given them the divorce. This is a problem. The Jewish community has got an equivalent kind of problem. It's not exactly the same, but involving something called the get. But Muslim women find themselves stranded because the husband has walked out. He hasn't pronounced the words of divorce. She, in the eyes of God, as far as she's concerned, if she's a devout Muslim, is going to commit adultery if she moves on by having another relationship. And so what these tribunals do is that they will grant a judicial, what's called a hulla, an annulment of the divorce. That's what these courts do. They don't go around saying you should have your hand chopped off and you should be stoned to death you should be beheaded for apostasy. They don't have any jurisdiction over any of these matters, and it's quite right that they shouldn't as well. But exactly as Mark says, it's very, very important that communities be allowed autonomy, because just as you have the Establishment Clause, you also have the Free Exercise Clause, and that's an entirely appropriate balance.
Okay, I want to go to Mark, but I want to ask you all one question, because the question I ask him is going to take a longer time, and I really wish you'd just give me a nod, because kind of a yes and no, if it's possible.
You're asking a bunch of lawyers to give you a yes or a no?
Would I be overly simplistic if I summarized the implications of what the two of you have said, if I said if anybody in the United States really understood Sharia as it ought to be understood, they wouldn't be worried about it?
I'd say they'd have no reason to be worried.
Right.
Yeah.
Okay. Now, Mark, whatever you call it, and I'm not going to just say Sharia, but Islamic law, whatever it is, what is the relationship between religious law and United States law? And can you, or will you, I know you can, cite some legal precepts about the protection that Americans have from the imposition of a religious law?
Okay. It's taken for granted. Can you hear me? It's taken for granted in American law that secular authorities, which would include the courts, of course, cannot impose religious law on unwilling parties. Strangely enough, there aren't a lot of cases that deal with that. I suppose I could go back to the 19th century. Occasionally one finds a judge who conditions probation on going to church. There's been litigation about Alcoholics Anonymous. But basically it hasn't arisen because the American tradition is so clear that the organs of state cannot be used to impose religion. Now we have debates at the margin. Is school prayer in which participation is voluntary, is that the government imposing religion, or is it simply accommodating the wishes of the majority? I've obviously taken one side to that debate, but that's different than imposing religious practices on people. Certainly in the last 100 years, that's not been a major problem. Again, one can argue about school prayer and the like, but basically that's not been a problem in the United States. So while nobody questions the principle, it's hard to come up with a lot of case citations for it. There is a debate, and actually comes from the fight over racial integration, whether judicial enforcement of private agreements that discriminate or use race or sex or one of the prohibited characteristics as a basis for a private contract, whether the state's involvement in the enforcement of that contract is the state itself enforcing religion. The race cases, which go back to the 1940s, after the Supreme Court in the 20s had held that you couldn't use zoning to exclude minorities, what developers did was simply put a condition on the sale of land that the land couldn't be sold to blacks. And the question before the Supreme Court in 1948, in Shelley v. Kramer, was whether the enforcement of those private agreements constituted state enforcement of racial segregation. And the court held yes. And so that has led to a 60-some-odd year now debate about what are the limits of that principle. In the early cases where, say, I invite people to a wedding, and I find out one of the invitees is black, and I don't want him to come or her to come into the room, can I call the police? Is that public enforcement of private discrimination, or is that permitted? The analogy to religion is now fairly easy. You have a private contract, the Muslim or Jewish marriage contract. Can you enforce that in the secular courts, or is that the secular courts enforcing religious law on people? And do you make the analogy to race directly? There, the results are mixed. New York has held, albeit in a close decision, that you can enforce private religious contracts, provided that the contract can be interpreted by the court without having to engage in religious interpretation. That is, if the contract, the religious contract, if the marriage contract says upon divorce, party A will pay party B X dollars, that doesn't call for religious interpretation, and at least in New York, that will be enforced. If it says the parties will divide property as provided in the Code of Jewish Law or the Code of Islamic Law, and the court has to go figure that out, that will be unenforceable. My impression is we have fewer cases from elsewhere. There is a decision in the Pennsylvania Supreme Court that suggests another result, but it dealt with child custody, so it may be not really terribly relevant. My impression is that if the parties know what they're signing, which often is not the case, you'll have an immigrant and an American, and the contract will be in a foreign language that one party did not understand. Basically, the courts will enforce it. And one of the reasons why they do so is Donald Trump. Because Donald Trump used to make a practice of keeping wives for 4 years and 11 months. And the reason for that was he had a prenuptial agreement with all of the, how shall we put it, young women he chose to marry. And the way the agreement worked is if you stayed married to me for 5 years plus, you got X. If you get divorced in less than 5 years, you get half X or a quarter X or nothing. And the courts will enforce those prenuptial agreements, subject to some terms about fairness and the like. So it's sort of hard to argue that Donald Trump can have his own domestic relations law and Islamic or Jewish believers can't. I've never, by the way, I use this analogy all the time. Nobody has ever come up with an answer to it.
Well, I also didn't expect to hear Donald Trump's name on this panel. But
I told you I would surprise you. There is an exception to the enforcement of religious arbitration agreements in panels. And that is, there's a sort of floating public policy exception. And some of that is in some of the latest versions of the so-called anti-Sharia laws, which is a public policy review. And it's amorphous. Now, it exists in all arbitration. It's not unique to this area. In New York, which is the state I'm most familiar with, it's a very relaxed review. It really has to violate a fundamental policy in really gross ways for the arbitration agreement to be set aside. We allow people to arrange their affairs basically as we choose to, but that is out there. So the sort of uncertain question about these enforcement of either religious marriage agreements or religious divorces, which include property and alimony settlements, is how rigorously the courts will use that public policy and equality argument. I don't think there's a lot of published case law. A lot of this happens in the divorce courts where in most states, at least till you get to the appellate level, nobody writes an opinion, and you really have no way of judging exactly what's going on. I would say that given the absence of case law, I would suggest there's not a lot of complaining going on and not a lot of untoward results, because we'd have, likely or not, opinions about it if there were. But that's a guess. I would add just one caveat. My very firmly held belief about people in divorce is you can't believe them very much. One or the other party or both will often lie or misstate or hide some of the facts in divorce. So when you talk to people and they tell you an anecdote about how well or how horribly they were treated, that translates to, I managed to hurt my ex-spouse or I got hurt, as opposed to an objective reading of reality. Now, that doesn't mean there aren't objective realities. It just means that I caution very much about anecdotal evidence being very determinate. One last, if I may, just one last thing. One of the things that the anti-Sharia movement has done is taken strange opinions from some local low-level judge and turned it into the average run-of-the-mill decision. Any lawyer will tell you that if you take enough judges, you will find one or more who do dumb things. And they sometimes do them spectacularly well. And, the Jersey case, the domestic relations, the beating case, which we've all heard over and over again, with some lower court judge, actually the facts are much more complicated than you're told, but it doesn't matter. He got reversed immediately by the intermediate appellate court in a very sharp opinion. It wasn't, this is a hard case, gee, we feel sorry for the trial judge, but we think it's the other way. No, this was, what was this man thinking, sort of reversal. So, again, anecdotes here, both because you can't believe the parties to divorce and because, there are judges who do dumb things, that doesn't mean the system as a whole does dumb things. Even upheld the health care bill.
Let me, Julie wants to, Julie, I knew
resist.
somebody would get that in. No, that's fine.
Hey, listen, if I can get Donald Trump in, I can get the health care bill in.
Health care, mysticism, and Donald Trump. Julie wants to make a comment. I know that we're running late. It took a long time to get everything on the table. If you have a question, really not a comment, but a question, go to the microphone, and when Julie finishes her comment, I will be glad to recognize you for a question. Julie.
And I'm going to be very quick. And this is really just in the interest of the fact that this is immensely complex, and there are just a few key things I want to make sure that everybody has heard here. First of all, Islamic marriage and divorce is not legal in the United States or Canada. Nobody who marries with a nikah only, nobody who gets an Islamic divorce only has either a legal marriage nor a legal divorce. That's why we see these as complementary and not substitution processes. And I just want to make sure that everybody gets that, because that's an important premise of what we're talking about here. If we substitute the billboard that says Sharia law is coming for Islamic law is coming, it seems to me that the most obvious question, and one of the reasons why I would rather that we frame the argument this way, is what laws are those that we're talking about? And the laws that we're talking about are predominantly these laws that relate to family relations. There is a certain amount of case law on the nikah. I mean, it's sparse, but it is out there, and it is getting reported. And I have read it all. And in almost every case, we have a few different contrary cases in Canada, actually. But in the United States, the courts are consistently refusing to enforce the nikah, even where that has all the elements of a binding contract, even where the promise is made in front of 500 wedding guests, because it is seen as having a religious quality. And I actually would say that that might affect a small number of women, but it is creating hardship for some women who cannot therefore successfully achieve their maha in that way and have to find other ways to try to negotiate it. And in the work that I did, which I would describe as qualitative research, not anecdotal information, I talked to many people, both women and men, where the women were frustrated with the fact that they couldn't receive what they saw as a genuinely promised payment to them, and many men who were well aware of the fact that the courts would not enforce that and therefore would hold out. The last point I want to make is the other part of this, which is divorce. And I think it's really important to understand that although we have historically seen some case law between other religious tribunals, for example, the Best Din, and the common law courts, in order to try to review arbitration decisions and so forth, we do not have any case law like that for what are called Muslim tribunals. And I just want to go back to something that was mentioned in relation to the UK. There you might describe the Sharia councils as tribunals. What's actually happening in North America is you go into the imam's office. It's not a tribunal. It's not an arbitration hearing. It's, could you come over to my house tonight and talk to me about the fact that I'd like to get divorced, or can I get an appointment in your office? We're not talking about anything that resembles a hearing here. That's a total misnomer. And at the same time, and we saw this in Ontario very clearly, the women and the men who go through those processes and who might feel dissatisfied with what the imam says, especially the women who are not given permission to divorce by the imam, they don't go to the courts. They don't go to the courts and say, I have an arbitration decision here, will you overturn it? First of all, it wasn't an arbitration. Second of all, it's what they believe to be the word of God expressed through the imam. So we had no case law in Ontario in the 13-year history of our Arbitration Act that allowed people to appeal those decisions. We didn't have a single case that involved an appeal out of a Muslim family context. Not a single one. We had about 2 dozen from the Best Din, not a single one. So when Ontario changed the law, they made no difference whatsoever to what was actually happening out there, because Muslims weren't using the courts to appeal the imam's decision anyway. So the case law we see is about marriage contracts. It's not about divorce.
Okay. Questions? Go ahead.
Joris Butenok, I'm a professor at Marist College. And I have a question for Julie and Sadakat.
Sadakat.
I'm sorry. So when we look at the Sharia courts or tribunals in Western world, for example, in Canada or parts in the UK, to what extent are they dominated by men, and specifically conservative men, and how that affects the rulings made regarding women's issues by these courts?
Yeah, I'm happy to go with that. Well, the simple answer is they're dominated by conservative men. It's in the nature of the beast. But that said, they don't. The functions that they perform aren't functions which are there to help men. There's this. No one knows exactly how many of these tribunals there are tribunals. How many? No one knows how many of these bodies there are in England. There was a statistic that was published in the Times in 2008 which said there were 10 of them around. Then there's a statistic which was published by a right-wing think tank called Civitas, which put the figure of 85 into the public domain. And that figure seems to have gone around now. Everyone uses it. It's not based on anything. If you look at the report, it's not based on anything. They didn't speak to anyone from any of these tribunals. Literally no one. Not anyone operating them, not anyone affected by them. So no one actually knows how many people are affected by them. The one thing that we do know is what they claim that they do, and what they claim that they do, and that's the only evidence that we've got, is that they offer annulments to women. And that's supported by lots and lots of evidence. Julie can support it with the research that she's done for her book, insofar as she researched the English side of things. She can certainly support it from the North American side of things. So the bottom line is that yes, these things are dominated by men, because that's who religious scholars tend to be, and the male-dominated interpretations of the Sharia have taken precedence over the last 1400 years. Female interpretations of it have existed, they've fallen by the wayside at many, many different stages over that 1400-year history, and it's very, very important. When I defend the existence of these tribunals, I don't defend every decision that they might possibly make, and there are certainly very, very important issues to be asked about. For example, what rules of evidence and procedure they're going to apply. Are they going to apply this rule which some conservative imams do apply, particularly in outside the West, of a woman's evidence counting for only half of that of a man, which is based on a Quranic verse which speaks specifically about business contests, but again, in centuries subsequent, that was understood to apply across the board. These are important questions, but the fact that they are dominated by men isn't a reason to say that their decisions are necessarily misogynistic. They aren't saying that female adulterers should get stoned to death. They aren't saying that there's no evidence to suggest that they are saying that the evidence of a woman should count for half of that of a man. There is, interestingly enough, evidence that they are putting forward the possibility of female arbitrators. Which is a step forward. If they're going to come up with human rights compatible interpretations of the Sharia, all power to them, I say. And that's the crucial thing. Not that one can expect them to by virtue of their gender balance, because one can't. But one can hope that they can do that, and one can push them in that direction.
Okay. Two sentences.
In
North America.
Okay.
In North America, we have imams doing this. Yes, they're all men. Their attitudes on what is the key question for women here, which is permission to be released for a divorce, range from the extremely liberal, looking at the Quranic texts and the liberalism with which the Prophet approached giving divorces to women, all the way through to women who I interviewed who went back to an imam over years and years talking about abusive, alcoholic, abandoning husbands who wouldn't be given permission to divorce. So we have a spectrum here. This is what happens with private ordering, that goes all the way from the heavily misogynistic to imams at the other end who will give women divorce under almost any circumstances. They're all men, though.
Yes.
I'm Nasser Sira from New York University, Abu Dhabi. I had a question. While the system may not do stupid things, I think there are a lot of people in the system and civil society who have preconceived notions and lead to institutionalized racism based on the concept of Sharia from the things they saw overseas, as we spoke about. Mr. Kadri said that lawmakers need to be informed as practical politics. So then, with as much ambiguity, who would be best and how would they advise these lawmakers about the nature of the Sharia?
Sorry, in which country are we talking about?
American Muslims.
Who would be best to advise lawmakers about the content of the Sharia?
Right, because you said that was crucial for them to be informed as practical politics.
Well, no, that isn't. I mean, I agree with Mark on this point. That the important thing is that these tribunals or body arbitrations, mediation panels, whatever you call them, be allowed to exist within the constitutional framework of the United States. I don't think politicians need to be advised about the content of the Sharia because it's not for politicians to address those issues. It's for religious scholars to come up with their interpretations.
Right, but I would say that the lawmakers and a lot of politicians do influence legislation and policies that do take part in this whole discourse around matters related to Sharia, and they should be informed as practical politics, as you said. So how are ways that people can, like the work Julie does when she Mrs. Julie does when she writes this book and says, well, this is the truth about Sharia. They're not talking about cutting off people's heads, cutting off people's arms. This is the implication for what it means for the American Muslim community. And I think there's a big ambiguity about what it is, obviously, and these are leading to prejudice and misconceptions. How can you best inform lawmakers, as you suggested needs to happen?
Sure. Well, no, I mean, you've answered your question to a certain extent in any event. I mean, of course, field work is important, and just saying, well, look at what American Muslims actually do. And the reality is that there are extremist interpretations of the Sharia as well. They're not at all prevalent in the United States. They do exist elsewhere. It's very important to look at these things clear-eyed, I think, to say that that there are these interpretations over in certain parts of the Muslim world, in countries like Iran and Pakistan. This is my view, at least. The criminal penalties that are imposed there are not penalties that I could ever support. But those aren't relevant to what's happening in the United States. There's not a bat's chance in hell that criminal penalties are going to be applied here, and that's entirely appropriate. I think all that one can do is simply just educate. I mean, it's a huge question if you're saying how can, because plenty of politicians come at stuff with agendas which have got nothing to do with the facts. They're not interested in being informed.
Really?
So I understand. They're not interested in being informed. But what one can do is one can lobby and one can argue and one can appeal to what I genuinely think is just ordinary common sense, which is shared by most American people. I don't think 70% of Oklahomans voted against the Sharia. I don't think 70% of Oklahomans were rabid Islamophobes, hateful, rabid Islamophobes. I think that most of them were just ignorant and had no real idea about what they were voting for. They were just the support was whipped up by a bunch of right-wing politicians, right-wing Republican politicians.
I would make look. I think there's at one level there's a need to educate about what it is you're talking about. Are you talking about something that 90% of, or 95 or 98, whatever the number is, percent of Muslims interpret in a moderate way, if not exactly American matrimonial law, then close enough, and 2% are extremists, or again, whatever the number is, and doing that in a sort of general education way, which I think you sort of have to do because of the reality of setting the tone. And something else, which is I think what we both heard in your question, which was if there's a Sharia law bill pending in the legislature, how do you persuade the members of the committee or the members of the legislature that really Sharia is a good thing, and there may be a little bad Sharia out, and if they want to be concerned about bad, that's okay, but not most of it, which is good. That, I think, is a horrible strategic mistake, to get into whether you ban a practice. I mean, I think if you look at the Catholic Church now over contraception, you have a body of Catholics who disagree with the Church's position and are lobbying the government to help them win the battle with the bishops. I don't think that has anything remotely to do with freedom of religion. And it's a huge tactical mistake which they will come to regret. If Muslims make the same mistake, they will come to regret it, because the permissibility of Islam depends on whether you can persuade people that this or that provision, which will, and it only matters when it's countercultural on some point, is good or bad. That's a mistake, and that's not helpful to religious liberty, not for Muslims and not for anybody else. However, in terms of general education, what we're doing today, it's very important. And that depends on the way you influence public opinion generally. And since we're on Twitter, it's clearly not by writing scholarly books.
Okay, let's get both of your questions on the table, and these will be the last questions. Yes.
Okay. My name is Nora Boozyhay from the University of Arkansas at Little Rock, and I have a question directed to anyone that can answer this, specifically Miss Julie. I know in Islam, from an Arab country, when you get married, you get a marriage certificate in that country, in the Islamic marriage certificate. And when you come to the United States, you have the United States marriage certificate. So when a couple gets a divorce in America, they get the United States marriage certificate. They're done. But are they technically still married if they didn't break off the Islamic marriage certificate?
Okay, that's very clear, and we'll come to it in just a second. Yes, sir.
Andrew Steele, Center for the Study of the Presidency in Congress here in D.C. Just want to thank the Newseum and all of you for coming today. This is a really important conversation. Professor Macfarlane relayed the Imam's quote, "There's a Sharia for every Muslim." That makes a lot of sense to me, and if Sharia law is a subset, the jurisprudence of that mentality, I'm wondering, is there a multiplicity of interpretation in the law? And if there is, my question seems to be, just reading Tariq Ramadan, I'm curious as to, is there a clear line of authority for who can interpret? What is the scope of that interpretation? Is it national or universal? And just how does that get meted out in the tribunals? Thank you very much.
Thank you. Julie's going to take the first question. Sadar second. Okay, yes, ma'am.
Sorry to join in late. My name is Sarah, and ironically, I attend the University of Kansas, which is a half-hour west of the famous Westboro Baptist Church. So it's interesting when someone wants to come up to me and talk to me about religious extremism. My question is, how is it that states, including Kansas, lawmakers in these states are able to pass these anti-Sharia laws that are involved in a concept that's grossly misunderstood? So in Kansas, they said that it was based off of all religious laws, but it's known as the Sharia bill. How is it that they're able to convince everyone of this grossly misunderstood and gain support of these grossly misunderstood laws?
Great. And Mark will take that one. So let's, Julie, begin.
You assigned it.
Yeah.
Okay, well, I want to say the reason they could do it is because there's always another. And at the moment, the other is Muslims. So there's always a place that we vest our fears and all of our, crazy, paranoid feelings. And at the moment, I'm afraid it's Muslims.
Okay, marriage and divorce.
Nice try to get out of that question.
The lady, yeah, I know. Yeah, you guys are the billing ones. Why am I getting this one? Okay, the lady who asked the question, where are you? Yeah, okay. If the marriage was legal in the country in which it took place, it would be legal in the United States. That's the principle of comity. If the divorce was granted in the United States, then as far as the United States is concerned, that couple is now legally divorced. When it comes to going back to the country that you came from, it depends on what country that is. And I interviewed lots of women who had been married overseas, divorced here in the United States, and were very fearful of going back to their countries of origin because they were afraid that they would still be regarded either legally or perhaps more importantly by their community as being married to their first husband. So I'm afraid the answer will depend. Legally, the answer is they are now divorced. The marriage is undone. But whether that means that the country they've come from will really recognize those people as asunder now, or whether their community will still regard them as essentially committed to one another, will depend on the family, the community, and the country. I'm sorry, that's not a clear answer.
And of course, that's not different from the United States and the way, for example, the Roman Catholic Church handles marriage, because you can have a civil divorce but not have a religious divorce. Right. Sadakat, would you take the second question?
Yeah, well, the question of authority, I mean, it's hugely...
You get that one.
Yeah, you've got 2 minutes.
I mean, basically, the Sharia does operate on the realm of faith. I mean, that's what I've been trying to say here. Islamic law operates at another level, but the Sharia operates clearly at the level of faith. And in that sense, every Muslim does have a personal Sharia. But the question is, what practical impact does that have? I mean, in many senses, what practical impact does that have? I mean, a religion can't function if every single person just understands the religion in their own individual way. A religion clearly has a collective component as well. And so you can't simply say that the Sharia is what you make of it, or Islam is what you make of it. I mean, it doesn't make sense. You can say that, but that's objectively just not true. I mean, as a matter of history, it's not true. So as a matter of reality in today's world, it's not true. But the practical question of who wields authority is a very, very important one. That can be answered simply by saying, well, it's a bunch of conservative, almost invariably male scholars. And that's certainly one very good answer, because that tends to be the way that they tend to be the interpreters of it in large parts of the Muslim world. But as a matter of, if you're then going to look at it as a matter of theological doctrine, there are said to be 4 sources for the Sharia. One is the Quran, one is the Hadith, these reports about the Prophet. The other is arguments by analogy. So if you come across a situation, a factual situation which hasn't been decided before, then you will argue by analogy with previously decided decisions. And the fourth is consensus. And so the consensus of the community, of the Ummah, the Muslim community, is regarded as being a source of the Sharia. But again, that opens more questions than it answers, because who is the community? And it's been defined in many different ways over the course of Islamic history. At times it's been all Muslims, at times it's been only the scholars. At times the Salafis would say it's only the first generations of Muslims. We go back to the 7th century, an argument analogous to the original intent argument used by conservatives here in the United States about understanding the Constitution. So there isn't every Muslim has their own Sharia, in the sense that every Muslim must find their path to God. That's certainly true. But that isn't a practical strategy for anything, really, because if you're going to say, well, who does judge and interpret the Sharia, as a matter of fact, it tends to be conservative Muslim men. And as a matter of practical reality, it can't really be everyone. There've got to be debates, and there've got to be arguments about this, and everyone, I believe, has the right to contribute to those arguments, but not everyone has the right to decide those arguments, because otherwise, that way anarchy lies, and that way just as many bad things lie as potentially good things lie.
Mark, why does what happens or may happen in Kansas happen?
Well, there are two things. If the question is why do legislatures do dumb things, I have no answer. Frankly, I would take a different public relations attitude towards the Kansas bill. I would declare victory. If you look at the Oklahoma bill, or the Oklahoma constitutional provision, it specifically lists Sharia and religious law and says they can't be enforced in our state. If you look at the later versions, and Kansas is simply the latest, they don't usually even mention religion. They talk about foreign codes, and they are a mix of the political motivation may be anti-Sharia, but there's a healthy dollop of anti-foreign law, which is an independent factor in the United States. Just last week, or earlier this week, the Supreme Court decided a case about life imprisonment for teenagers. When they first got to the question whether how the Constitution applied to punishments for teenagers, the court looked overseas, looked to international law. And there was a whole furor, and it became a factor in confirmations. And so this time, the only person who mentioned foreign law was one of the dissenters. The majority carefully didn't mention foreign law. If you look at the Kansas law, on its terms, it's more anti-foreign law than it is particularly Sharia, even though I would think that the anti-Sharia politics pushes the bills through. In fact,
but Mark, don't you think they've only changed that because of the Oklahoma case?
Yes, okay, but so what? I take my victories are hard enough to achieve. I take them any way I can get them. And
I'm sure that's why they've redrafted it.
Right, I'm sure that's true. And in fact, business opposed some of the earlier versions because business would have made life impossible. So yes, it's true the politics are noxious. On the other hand, in the real world, any lawyer worth his salt or her salt can get around these bills. You simply write a provision that says, we voluntarily agree to arbitrate this way. We know we could go to another court. We nevertheless decide to do it. I pretty much guarantee that any court in any of these, Kansas or anywhere else, will enforce that agreement. So it's about symbolic politics, partly anti-Islamic, partly, and should not be ignored, anti-foreign generally. And I would be prepared to declare victory instead of bemoaning a loss. I'd claim it as a victory.
Let me say that these are smart people who know how to communicate what they know, and I think they've helped us today. Thank you.